So Deputy Attorney General Ryan Bangert, thank you very much for making time to be with us. I appreciate it.
My pleasure, and glad everything worked out.
Yeah.
The adventure's there, but it seems like things are panning out quite well.
Let's start with the basics. Give us a rundown. What is the status of the lawsuit to invalidate the ACA, and where does it stand right now?
Sure. So the ACA lawsuit that we're referring to is the most recent case that was filed back in the beginning of 2018. And it's fairly characterized as a follow-on to the NFIB versus Sebelius lawsuit that was decided by the U.S. Supreme Court in 2012. This lawsuit, which is Texas versus United States, it's styled Texas versus United States, was filed in the Northern District of Texas, Fort Worth Division, Judge Reed O'Connor. It was filed back in February of 2018. In December, on December 14th to be exact, Judge O'Connor issued a ruling, and that ruling granted partial summary judgment on one of the claims in the lawsuit. There are 5 claims. The first claim in the lawsuit was a claim for declaratory relief, asking the court to declare a specific portion of the ACA unconstitutional. And that specific portion was the individual mandate. That was the subject of the Sebelius lawsuit.
And the logic of that claim is what? Explain that. Explain how the change in the tax rate or level impacts that.
Sure. So that's a great question that we could probably spend a lengthy amount of time unpacking. But the easiest way to do that is to go back to 2010 when the NFIB lawsuit was filed. At that point in time, the individual mandate had come into being. And there's a little bit of confusion about what is and what is not the individual mandate. What are we talking about when we use the term individual mandate? Well, Section 5000A of the ACA contains the individual mandate. The first part, subsection A, says that certain individuals must purchase insurance that meets the 10 essential health benefits. Now, that portion of the statute was accompanied by a second piece, subsection B, which provides if you do not purchase health insurance that meets the requirements of subsection A, you must pay a penalty. And that penalty was the subject of the NFIB lawsuit. So when that lawsuit was filed, the government attempted to justify the mandate using the Commerce Clause power in Section 1 of the Constitution. And the Commerce Clause power provides that Congress may regulate interstate commerce, commercial activity. The argument was made by the challenging states, Texas is one of them, that no, you cannot regulate commerce in such a way as to force people who are not engaging in commerce, i.e. people who haven't purchased insurance, you can't force them to go out and buy insurance because that's not regulating commercial activity, that's actually regulating a lack of participation in commerce. Mm-hmm. Now, the Supreme Court, 5 justices agreed with that argument. Justice Roberts, accompanied by what's now called the dissent, the joint dissent, Justice Scalia, Alito, Thomas, and that time Justice Kennedy, all agreed that the Commerce Clause doesn't allow Congress to force individuals who are not engaging in commerce, people who have not purchased health insurance, to go out and engage in commerce. You can't force that activity. But Justice Roberts saved the individual mandate with the cooperation of 4 other justices. So you have Kagan, Breyer, Sotomayor, so you have, and Ginsburg, who wrote the opinion. So those 4 plus Roberts said, it doesn't qualify as an exercise of the Commerce Clause power, but when you take the mandate, the requirement that you buy insurance, and accompany it with the penalty, it looks like a tax. And so it's valid under, according to the reasoning of Justice Roberts, it's valid under the taxing power that Congress has.
Yeah.
So that was the decision of NFIB.
So the taxing power is something Congress can do, even if they cannot compel you to take action in the marketplace, cannot compel you to buy something. They can certainly tax you, as part of the understanding there.
That's right.
And then the House and the Senate can reduce the level of that tax without 60-vote filibuster-proof majority needed for cloture. Can reduce that tax from $7.95 or 3% down to $0, which is what happens. Why does that in the Attorney General's view and the office's view, why does that change the nature of the individual mandate?
Sure. That's a great question. And that question really cuts to the heart of the current lawsuit, Texas versus United States. There are two questions at issue in the Texas case right now. One is the individual mandate authorized? Does Congress have the power to impose the individual mandate without the penalty? And the second question is, if not, if Congress doesn't have that power, well, then what happens to the rest of the ACA if the mandate falls? So to get to your question, how do we view the case in light of the 2017 Tax Cut and Jobs Act, which effectively zeroed out the penalty? So remember, you have two parts to the mandate. You have the command that you buy insurance, and then if you don't, there's a penalty. You have to pay a penalty, and that penalty is calculated based on a formula that's contained elsewhere in the Act. Well, what Congress did was it zeroed out the penalty. So now you have the mandate, that the command that you buy insurance standing all by itself. But there's no penalty, there's no what Justice Roberts called a tax to back it up. So a lot of this gets to how Justice Roberts framed the issue. He said that the penalty was effectively a tax on not doing anything. If you choose not to purchase insurance, the government can choose to tax that activity. That's how he framed it. Now, he admitted in his opinion that is not the best way to read the statute. The best way to read the statute is really what Congress intended, which is there's a command, and if you don't obey the command, you suffer a penalty. But in order to save it, because of the Commerce Clause interpretation, they had to call it a tax. So you take the tax away, well, there's nothing left to justify the command, the bare command that you purchase insurance, because you can't pair it up with the tax anymore.
You're touching on this thing that those of us who aren't lawyers don't spend a lot of time thinking about anymore, but that 2012 decision was really quite creative jurisprudence. I mean, there were a lot of, as you said, there were 5 votes here, 5 votes there, different majorities. There was a 7-2 majority on a different issue that you reminded me of earlier. And it appeared even that Chief Justice Roberts may have changed his opinion in the last few days in the run-up to the final opinion. So for those who say, look, this issue of the constitutionality of the Affordable Care Act has already been decided, it seems like the NFIB case, for a host of reasons, including the creativity, may not have a lot of application to this decision. What do you think about that?
There's a lot to unpack in that question. We think it has direct application, and Judge O'Connor believed it did, on at least one very important question. And that is, you take away the penalty, so you no longer have the tax argument that Justice Roberts relied upon in his creative jurisprudence in the initial NFIB decision. You take away the penalty. You're left just with the command. The only way to justify that command without the penalty is under the Commerce Clause. NFIB very clearly, there were 5 justices who clearly held that the Commerce Clause does not allow Congress to regulate inactivity, to force individuals to engage in commerce. That's a clear holding. You have 5 clear votes for that. So that is precedential in our view, and Justice O'Connor agreed. That is precedential. So the command that you buy insurance cannot stand under the Commerce Clause, clearly can't stand under the taxing power because the penalty is gone. What they call the tax is now gone. So the mandate has to fall under the reasoning of NFIB, and that's exactly what Judge O'Connor in Fort Worth held.
Do you think there are certainly smarter people than me that have differences of opinion on all of this? That's why we have courts. Do you think that the creativity of that 2012 case, and there was a later case, King versus Burwell, that's got some relevance, do you think that actually just sort of throws open the law, the case law, the jurisprudence here in this decision? I mean, for example, creativity could say, just because the tax has a rate of 0 does not mean the tax is gone. The tax is on the books. The tax clearly is on the books. The tax was not repealed. In fact, it was Congress's intent to not repeal the tax. Had they wanted to repeal the tax, they would have repealed the tax, and they decidedly did not do that.
that precise argument has been made in this litigation. The argument is, well, there's still a tax, it just happens to be zero. And key to Justice Roberts' decision in NFIB was how do you characterize this penalty as a tax? How do you convert this into a tax? Well, he looked at the essential hallmarks, the essential characteristics of a tax. One of those essential characteristics, in fact, the most essential characteristics, is that a tax raises revenue for the federal government. If you zero out the penalty, it loses that essential characteristic. Mm-hmm. It no longer can be treated properly as a tax, which, quite frankly, it never should have been. But you lose the ability to recharacterize the penalty as a tax when you strip it of its essential characteristic of raising revenue for the government. But that argument has been made. It's just a zero tax. Well, it's no longer a tax. It can't be treated as a tax, even if it could have been earlier, because it no longer raises revenue. But in terms of creativity, there's another point that's very important to touch on that wasn't entirely resolved by the NFIB decision, and that is severability. Mm-hmm. What happens? So assume that the mandate is unconstitutional, exactly what Judge O'Connor held. What happens to the rest of the ACA? What happens to the remaining provisions? Guaranteed issue, community rating, all the other pieces, Medicaid expansion, go on and on. What happens to those pieces of the ACA? Well, there were 4 judges, the joint dissent, who held that you could not disentangle the mandate from the rest of the act. The rest of the act was all interdependent. Mm-hmm. The mandate, community rating, guaranteed issue, all of these things worked in harmony and concert to create the type of policy that Congress wanted to enact. And so 4 justices held that you could not extract the mandate and have the remainder of the act stay in place. It all fell together like I think Judge O'Connor called it a big Jenga puzzle. You're pulling out the pieces of the puzzle, and it just so happens that the mandate happens to be that piece. When you pull it out, the whole stack falls. And that's exactly what Judge O'Connor held in his December opinion.
There are a number, of course, Democratic attorneys general that criticize this judge as being perhaps more conservative in his decisions than other judges might perceive appropriate. And the Fifth Circuit is not necessarily a progressive court by any stretch. But there are even conservative judges or conservative legal scholars, I should say, that argue that this district court opinion is a bit of a stretch from the view of legal scholarship. Some of the criticisms include, to your point on the severability, that because this tax rate has been adjusted to zero, would not be appropriate given Congress's intent and given the Supreme Court's previous rulings. It wouldn't be appropriate to also strike down Medicaid expansion, that this was an ambitious ruling. What would you argue back to some of the conservative scholars who have found criticism with this ruling?
Sure, that's a very good question, and it presages, and I think it highlights the fact that this area of severability, there's a lot of intellectual and academic churn in this area. And because it wasn't squarely decided by the Supreme Court in NFIB, there's a lot of debate. What I would respond to is this, and quite frankly, there are the 2 issues, whether or not the mandate is constitutional can be separated from severability. Most scholars agree, especially the ones who are conservatives who are criticizing the severability decision. Most of them agree that the mandate is unconstitutional, absent the tax, absent the penalty. But the severability question is more challenging for them. How you decide severability is very simple. You look at the intent of Congress. And the question you ask yourself is this: absent the piece that's unconstitutional, in this case the mandate, absent that piece, does the statute work the way Congress intended? And would Congress have passed the pieces of the statute that remain without the piece that's unconstitutional? So there's a little bit of, you're engaging in counterfactuals here. Mm-hmm. But that's the analysis that's typically done. And courts often will look for clues that Congress has left behind. And here we have a very clear record in the ACA itself, where over and over again, Congress described the individual mandate as essential to the working of the statute. And the word essential is actually written into the statute itself. It's essential to the interoperation of the various pieces of the statute. And even when the Obama administration, the Obama Department of Justice was defending the statute in the NFIB case, conceded that at least two pieces of the ACA were so interdependent and dependent upon the mandate that if the mandate fell, those pieces would fall as well. That was guaranteed issue and community rating. And the Trump administration has continued to maintain that position. The Trump administration has not conceded that the entire act is unseverable, but the Trump administration has maintained the Obama administration's position of conceding that guaranteed issue and community rating are no longer appropriate. They're not severable.
Yeah.
Now, we would argue the entirety of the act, we have argued that the entirety of the act itself is not severable, and there's a very good and lengthy description of the reasoning for that in the joint dissent's opinion in NFIB, where they go through and they detail exactly how each of the various provisions of the ACA interrelate and depend upon each other to create the type of policy that Congress intended.
You know, it's interesting too. It's so funny how, I don't know, funny. It's just that, you know, governments are constructed of men and women. You all may remember the 2009-2010 Affordable Care Act determination happened following the 2008 election, where President Obama sweeps in a bunch of Democrats in the House, sweeps in a bunch of Democrats in places like Alaska and Nebraska in the Senate. So there's a 60 vote filibuster-proof majority in the Senate. The Affordable Care Act comes out of the Senate Finance Committee and the Senate side. And in Congress, they always pass the Senate bill and they pass a House bill and they kind of clean it up in conference. Well, they passed this Senate bill, hadn't cleaned it up yet, had not included a severability clause. This thing that we're talking about 8-9 years later had not included this clause that is always included in every bill because they were going to get back and clean it up in conference. Well, the point between which the Senate bill passed and when the House took action, not only did Senator Ted Kennedy pass away, but he was then replaced in Massachusetts by Republican Senator Scott Brown. So that 60 vote majority disappeared. It was 59 votes, and the House had to adopt the Senate bill in order to get the votes. And so the fact that they didn't have this severability language is really central to the argument you're making legally.
You're right. And
there's additional context, but that's a really key piece.
But you do raise a very good point. And there was a severability clause that did end up included in the ACA, but it pertained to the Medicaid expansion piece.
Was that through the rewrite?
It was
for Chief Justice Roberts' opinion?
He pointed, it was actually in the statute itself. There was a severability clause embedded in the Medicaid expansion
for
portion.
Expansion, interesting.
But it was only applicable there. And so one of the issues we didn't touch on in the NFIB case was whether or not the Medicaid expansion piece of the law was constitutional. And the challenge to that piece was that the Congress had commandeered, had dragooned, in the words of Justice Roberts, had dragooned the states into expanding Medicaid, because if they didn't, all of their existing Medicaid funds would be withdrawn.
Yeah.
And that was a commandeering argument. The 7 votes on the Supreme Court agreed that the Congress could not do that. Congress could not condition the receipt of existing Medicaid funds by the states on an expansion of Medicaid, but they held that the Medicaid expansion, shorn of that penalty, could stand.
Yeah.
Because there was a severability clause. But what that also had the effect of doing was highlighting the fact that there was no severability clause attached to the mandate.
Yeah.
So it was missing.
I was originally going to ask you a question about why the Medicaid expansion would not be severable, since the individual mandate did not really apply to people affected by that. If they were below the poverty level, they were exempt from that anyway. So how could that have to do with Medicaid expansion? But if you're saying there's already language in the statute that severs that from the rest of the bill, then why does not the Medicaid expansion provision of the Affordable Care Act stand even if the rest of it falls?
I think your question is, if the mandate is withdrawn, why wouldn't you have the Medicaid expansion piece stand absent the mandate?
That is part of my question, but the other part of my question is, you had alluded to the question of severability and whether part of the law could stand and the rest of it not. And you just said that there's language in the Affordable Care Act making the Medicaid expansion section severable. So isn't that severable from the decision that's just been rendered, that the whole Affordable Care Act is thrown out because of the individual mandate problem?
Yeah. That's a very good question. Oddly, that hasn't been squarely teed up in the briefing yet. But that is a good question. The way that the NFIB joint dissent looked at the issue that you're raising is no, it could not be saved, because the way that the mandate operates is to bring more people into the system to offset the additional costs that are being imposed by guaranteed issue, being imposed by community rating. And part of that ecosystem that's being created involves expanding Medicaid to provide a backdrop so people who are exposed to the mandate, who need to comply with the mandate, have a place to go if they're below at least 133% of the poverty line, I think is where they set it eventually. But it gave them a place to go. And so if you take the mandate out, you no longer have individuals who are forced into these various either purchasing policies on the exchange or moving into the Medicaid expansion, and they may end up uninsured, which could damage the system that Congress was looking to establish. And so the argument, at least from the NFIB dissent, would be the mandate is so central to the operation of all of these parts that even with that limited severability, where you could sever it if it wasn't combined with the requirement that you accept those Medicaid funds on pain of losing your existing Medicaid funding, because that's really where the severability clause was applied. But even if you set that aside, these parts are so interoperable that the entirety of the act has to fall. So it's a little bit of a complicated legal argument, but the argument that you're making, I would expect at some point a lawyer to raise that.
Yeah, okay, I'll just make one other comment then. If I understand you correctly, and you're saying that there's an argument waiting to be made, just hasn't been made yet. But I also would challenge you just to respond to this. The act does not subject a penalty to people below the poverty level, and that is the largest share of the Medicaid expansion population. So there is no intrinsic relationship between the mandate and the Medicaid expansion, because most of those people were never subject to it in the first place. So how is there a tapestry there that will get unwoven if you take that away?
Yeah. So the argument that you're raising there is one that's been raised currently in the litigation. And that is the question of, if you shear from the mandate the penalty, does it really operate as a mandate? Does it really operate as a requirement to purchase insurance or move into one of the available places you can get coverage, Medicaid? The response argument to that is, even without the penalty, the mandate is still a requirement. It's still a command to purchase insurance. It's still something that, and I believe the CBO phrased it this way: some people are going to obey the law just for the sake of obeying the law. And that argument from the CBO has been repeated multiple times in the case law, in the decisions that have been rendered in this area. So you still have a mandate, regardless of whether or not there is a financial penalty for disobeying the mandate. You still have the command in 5000A subsection A that exists and that is still on the books. So that's one of the responses to the argument you're raising. But the argument that you have raised is the very argument that was raised by the intervening defendant states when they filed their motion asking the district court to stay its ruling in late December. So this is something that is being litigated.
Hi, I'm hoping you can speak just for a second a little bit about the policy behind, and maybe the politics behind, the state of Texas filing this lawsuit. I may be wrong on my dates, but I think it was after the risk pool was abolished. And so if this lawsuit succeeds, there will be virtually no individual market in Texas unless Congress or the Texas legislature acts. So sort of what was the thinking behind that when you filed the lawsuit?
The reason that we brought the lawsuit was to defend the rule of law. It's not to create policy. We're not a policy-making organization. We are the state's lawyers. And the reason the lawsuit was brought was because the Constitution wasn't followed. It was purely to defend the rule of law. It wasn't to set policy for the state. That's the job of the legislature. The governor will implement that. So we're not trying to make policy for the state. But there was very clearly some constitutional problems with the way that the ACA was set up. And the Commerce Clause problem was central to that. And so the reason that, if you ask the reason for why the lawsuit was filed, is because the Attorney General's office has an obligation to faithfully defend the state when there are legal issues in front of it. And we clearly perceived that Congress had overstepped its constitutional authority when it implemented this law, when it passed this law, and imposed these obligations on Texas. So it was purely from a legal perspective that we viewed this, and it was not a policy perspective per se.
We're getting short on time, but I'm wondering what you think as an attorney, as Deputy Attorney General, under the past President Obama, this line of thinking began, and President Obama faced a record number of lawsuits brought by states against the federal government during his administration. We continue to see that pace continue now under this Republican administration, where Democratic states are suing the federal government. And we've sort of entered into this new period of federal state litigation or activism via the courts in defining the federal relationship and sort of defining the dual sovereignty nature of the state-federal relationship. Is that good for America and policymaking? Because it's different. It's a little more active, and it's on both sides of the aisle now. So this is sort of a legal philosophical question. Are we entering into a period of legal activism that is good because it's checking the federal government, or are we undermining something that's maybe getting lost?
That's a very good question. It kind of goes to what you've seen happen over the past decade or so. And you're right, the activity by the state attorneys general is on both sides of the aisle.
Yeah.
You've seen a lot of litigation brought now by blue states, so-called blue states, with respect to the Trump administration, continued activity on the part of red states. I think it's an unalloyed good. I think it's a good thing because I would not call it judicial, I would not call it activism, I would call it federalism in action. Federalism in action. The way that our government was structured, we have vertical and horizontal federalism, of course, federal to state. And in this instance, you have the states fulfilling their role, the role that we believe was envisioned by the framers of the Constitution, which is to serve as a balance and a check on the federal government, being jealous guardians of state prerogatives and states' authority, which was reserved to them by the Constitution. And when the federal government oversteps its bounds, it's entirely appropriate for a state attorney general, whether left or right, to check that through the legal process. And that's why we have the federal courts, that's why we have the Constitution and the ability of state attorneys generals to bring these actions in federal court. So I think it's absolutely a good thing. I think it's a good development. I don't think it's activism so much as federalism and constitutionalism in action.
Good. Ryan Bangert, the Deputy Attorney General for the state of Texas. Sir, thank you very much for being with us. Let's give him a round of applause. Thank you, sir.